Hi, good morning, good evening, everyone. Thank you so much for joining us today for this program on enforcing institutional arbitration awards in the U.S.-India corridor. We hope today that our speakers will give you a practical guide to help sort through some of the issues when looking at arbitration and other ancillary issues to enforcing arbitration awards. You know, the topic is really relevant today because following the release of India's budget yesterday, we know that the government of India wants to elevate India to become more integrated into the global supply chain and to make it easier to do business in India. But contract enforcement and the potential to get trapped in years of litigation in India remains one of the paramount concerns for US investors when looking to enter or expand in the Indian market. And therefore, it's no surprise that many investors turn to arbitration, particularly Singapore, to mitigate any disagreements or risk issues when entering into the market. My name is Amy Hariani. I'm a senior advisor for the U.S.-India Business Council. For those of you not familiar with USIBC, we're the biggest bilateral trade association in the U.S., representing U.S. and Indian business houses that promote, grow, and expand trade ties. We count among our members all of the Fortune 500 companies in the US, as well as many of the major Indian houses, but also law firms, both international law firms and Indian law firms. And I am so pleased that one of our favorite law firms is Ketan and Company, who's hosting the program with us. I also want to thank SIAC for jointly hosting with us as well. Before I turn it over to our moderator, let me first just give you a bit of a background on Ketan. They're actually one of the oldest and largest law firms in India and a longstanding member of the U.S.-India Business Council. I'm proud that Hegreeve Ketan serves on our India Advisory Council. It started in 1911, so it's over 110 years old and full service in every way. So not just on arbitration and enforcement of arbitral awards that we'll talk about today, but litigation, IP, healthcare, all sorts of issues. Ketan is a go-to law firm for them, and I'm pleased that I often recommend them to many of our members who have issues in India. They actually just recently opened an office in Singapore, so this is also very timely as we look to SIAC in partnership with the Singapore International Arbitration Court. And so I do want to now turn it over to our moderator for the program, Paku Khan, who I count as one of my dear friends. Paku is based in the Bay Area, so I haven't got to see him in person since the pandemic, but I'm looking forward to doing that soon. He is an executive director on both of the firm's US desk and competition and antitrust practice groups. He has more than 30 years experience in competition, merger control, corporate and related litigation experience in the US, India, the European Union, and is regularly featured as one of the top competition law leaders in India. Paku, thank you for inviting the US-India Business Council to partner with you on this really important topic, which I know is top of mind to many of our investors and businesses here in the US. And thank you for your partnership with you and the firm with USIBC. Let me turn it over to you to take it from here.
Amy, thank you so much for the partnership and friendship over the years. And so I want to thank you and the U.S.-India Business Council as well as SIAC for co-sponsoring this. Let me quickly get to the topic. And why we're here today is enforcing institutional awards in India. And first of all, and most of all, I hope everybody is well and staying safe. And as Amy's presence demonstrates, we really want to focus on the US-India corridor. I think this has applications to other jurisdictions, but the US and India in particular have had strong trade relations for many, many years. The US-India bilateral trade in goods and services reached $149 billion USD in 2019. Just to give some little more in the way of the India relationship, India was the US's 11th largest overall goods trading partner, and the US was India's largest merchandise export destination and third largest merchandise import supplier. And that's just for starters. That relationship is growing and growing and growing. Now, when we talk about relationships at the micro level between companies or among companies, we're also talking about contracts. And sometimes contracts don't always go the way that you want them to. And we can be talking about any kind of contract, whether it's service ventures, PE and investments, M&A. It can be as broad as the imagination of humanity on where those contractual relations are. And where you have contracts, you may have disputes. And the whole concept, as we know about arbitration, is to make that resolution of a potential dispute easier. But the problem is that the award of an arbitral award itself is not the end of the game, especially where you've got international arbitration and you're dealing with an Indian party on one side. How do you enforce that arbitral award? And that's what we're going to be here to talk about. Amy had talked about the importance of dispute resolution on India's ease of doing business. Let me give you one compelling statistic on how well India is doing. In 2014, India was the 142nd easiest place to do business, so therefore it wasn't that easy. I think that was in 2015. And in 2020, the World Bank rated India the 63rd easiest country to do business. So it's not the easiest place, but it has made huge leaps and bounds in 5 or 6 years. And dispute resolution and arbitration is key to that. So today we're going to be talking about enforcement and the enforcement process in India, what interim measures a party can take, and what a party can do even before an arbitration starts to make it as effective as possible. So enough of my talking, and let me introduce a really, really fantastic panel. First of all, we have my partner, Raj Panchmatia. He's based in our Mumbai office, and he's a partner in our dispute resolution practice group. He has a rich experience of the field of dispute resolution and commercial litigation, both at the domestic and international levels, and has advised clients on a variety of claims under the Indian arbitration laws, as well as those of SEAC, LCIA, ICC, UNCITRAL, HKIAC, and has extensive experience in disputes under all forms of contracts and agreements. Raj is also a SEAC panel arbitrator. Next, we're very privileged to have Stephen Lim coming to you from Singapore, where it's just very late and also just during the Lunar New Year holiday. So Stephen, thank you so much for joining. Stephen is an arbitrator and barrister, and he has significant experience with international arbitrations involving US and India parties seated in and outside the US and India as both arbitrator and counsel. He's had over 80 appointments in international cases as presiding, sole, co-arbitrator, and emergency arbitrator. And he's on numerous panels, including SEAC, HKIAC, ICDR, KCAB, GCAA, CITAC, and so on. And Stephen, forgive me if I've forgotten some of those, but your accolades are many. He appears as lead counsel in international arbitration and is a member of the English and Singapore bars. And just very quickly, he's been noted in legal directories as the perfect arbitrator, fair-minded, highly respected figure across the gamut of APAC-related commercial disputes, and an excellent counsel with an excellent understanding of law and great commercial insight. So Stephen, thank you so much for joining us. And last but absolutely not least, we're delighted to have Shweta Bhaduri from SEAC's Mumbai office, where she is the head of the South Asia aspects of SEAC. Prior to joining SEAC in November of 2018, Shweta worked in the dispute resolution practice of a leading New Delhi law firm for nearly a decade on commercial litigation cases, as well as investment treaty arbitrations involving foreign and Indian investors. And she's worked on many leading cases which have contributed to the development of law affecting global companies in the area of arbitration and dispute resolution. And then as Amy indicated, my name is Paku Khan. In addition to being an antitrust lawyer at Ketan & Co., or KCO as we call it, I also serve as the on-ground coordinator for our US-India desk. So as Amy indicated, we want to make this as practical as possible so that you can take away some really, really specific issues on, frankly, what is a niche but important area. And so just to give you a quick outline of today's program, we're going to go for around 90 minutes. So in Pacific time, we would end around 10:30 a.m. Eastern US time, we'd end at around 1:30 p.m. and unfortunately midnight in India. And we'll take about 60 minutes of that 90 minutes for our panel discussion, and then around 15, 20 minutes for questions, which we'll take at the end. And I believe there's a chat feature on your webinar platform where you can enter questions. So keep in mind, we'll try to get those at the end. And if for whatever reason we run out of time, we'll address those by email. So let me then now turn it over to our panel where we've had huge interest in this topic. And let me start it off with Raj. Can you give us an overview of the enforcement environment and the landscape for arbitral awards in India?
Sure. Thank you, Paku, and thank you, SIBC and SIAC, for joining us today. As a matter of, as Paku mentioned rightly, that getting an arbitration award is fairly easy. Going through an arbitration process is fairly easy. The devil is when you have to enforce it. And that's the key. And where to enforce it, how to enforce it, whether you're in the right jurisdiction to enforce it, where the assets are, that's the key. But when you come into India for enforcing a foreign award, you need to keep in mind a few things, especially how quickly you want to enforce it, what are the kind of reliefs that you are looking at, what are the urgent assets that you want to attach. So there is a huge gamut of things that you need to keep in mind. Enforcement, a foreign award to enforce in India has now become much easier, and the judiciary in India has been very progressive and has been supporting enforcement of awards into India. Earlier, the enforcement of foreign awards used to take a pretty long time in India, but now enforcement has become much faster as compared to earlier. Court interference in enforcement of awards has also reduced. So in that sense, I think the government of India, the judiciary, and everyone is working towards projecting a right and taking right steps, I would say, to enforce foreign awards in India. When you come to enforcement of an award, it could be an interim award as well. But if it's an interim award, it has to attain a finality on the issue which it is determining. So it may be an award or an interim award that you may want to enforce into India. Again, there is a bit of a gray area on enforcement of an emergency award right now in India. While if it's an emergency award where a seat of arbitration is India, but if the if it's an SIAC rules, you will still be able to enforce it. But there's still a bit of clarity required if the seat of arbitration is outside India and to enforce an emergency award. So there is a bit of a clarity that's required here still. What I would say is that while there are, when you bring an award into India, the first thing that you have to then do is to file for an application under section 47 and 48 of the Arbitration and Conciliation Act, which is for recognition and enforcement of an award in India. Now, when will you bring an award into India to actually enforce it? So before you bring an award into India, you will have to keep in mind that award has attained finality in the country in which it was passed, so that there is a finality to the award. Once you have a finality to the award, you bring the award to India for enforcement, recognition and enforcement. It's a two-step process, but in India, you file a common application for recognition and enforcement under section 47 and 48. Now, pending enforcement, now when you come to India, you may sometimes consider, I'll go to India, but then what do I do? How do I how do I identify where the assets are, what the assets are, how do I go and enforce it? So there are a couple of ways to do that. One, you can actually make an application to the court requesting the other party to disclose their assets which are there and which can be attached, or in an injunction can be granted against. Or before you go and file that application, you may on your own would want to consider engaging an asset tracing agency who would have done that exercise of identifying where the assets of the counterparty are, and you make that as a part of the application, and then you go to the court and say that we would like to immediately get an injunction on these assets which are easily available or which have been identified, and then request for the further disclosure. While the process in India has smoothened and it's become much faster, but you must know that it will still take some time because it's not that quick also, and therefore roughly a rough time estimate would be between 1 to 2 years to get the final enforcement. Don't expect an immediate enforcement, that you will get an enforcement, you file it and you'll get it in 1 month or 2 months time. You may be able to get an injunction that pretty quickly. You may be able to get a freezing order on something, or you'll be able to say that no assets can be transferred anywhere. But to complete the entire enforcement process would take some time, and therefore it's very important to know that while it may take time, but there are some fixes that you can take, and we can discuss that going forward in the webinar uh, as well. So I think these are some of the things that you must keep in mind while uh, bringing the award into India. A couple of things that you also need to keep in mind is that when you are enforcing an award into India, and if the award was passed in a country which is a signatory to the New York Convention or a Geneva Convention, enforcement in India is much easier because India is also a signatory to the New York Convention and the Geneva Convention. If you have a award from a country which is which is also a signatory to the New York Convention, and India is also a signatory to the New York Convention, and India has also ratified that country as required under law, then enforcement becomes much easier. But in the event that you have an award from a seat which is not a signatory to the New York Convention or a Geneva Convention, enforcing that award in India is that much more challenging, and it may take even more time because you will have to come to India and file a suit in India for enforcing that award, which will then increase your timelines. You may of course be able to use the award as an evidentiary value. You may also be afterwards be able to make any applications on interim reliefs in the suit, but you will have to file a suit in India to get your reliefs. So therefore, it is very important that where you seat in arbitration, and that the seat of arbitration is at a place which has a reciprocating arrangement with the country in which you want to enforce the award. And therefore, you have to be very clear where the assets are, and whether the country where you have seated an arbitration has a reciprocating arrangement with the country where the assets are. Sometimes it may be you may find that assets are in multiple jurisdictions. Then you may want to go to a particular jurisdiction. So that's also very important. Another important aspect of it is when you are bringing in a foreign award for enforcement, it'll have which court will you go to is the biggest question that everybody has. Which court do I go to in India? There are so many courts in India. Which court do I go to? You'll have to go to a court where the assets of the counterparty are primarily located. It's a test that is generally followed as to whether defendants reside, where the assets are located, and a court which would otherwise would have an original jurisdiction to try a suit against a party. So therefore, you'll go to a state and the high court in that state to enforce that award in a particular jurisdiction. So by and large, this is what a brief overview of the uh, of a foreign award and how you would want to enforce it in India. Uh, one important point that you must also keep in mind is when if it's an international award, an award coming from a foreign country, and if it is not stamped, it is not a problem. But when it's an domestic award, it is required to be stamped. And if it is not stamped, then there are multiple complications that may arise. So if it's a foreign award, need not get stamped when it's brought into India. So generally, it's a lengthy process. But if you are going to, if you want a quick fix, there are some quick remedies that are available, and it may not be a full fix at the first instance, but in the long run, you will be able to protect the assets which are subject matter of the award. Thanks, Paku.
Okay, Raj, thank you for that comprehensive overview. Let me turn to Stephen. I'm going to ask you two questions, Stephen, that are related. You've had vast experience in international arbitrations. Anything that you see peculiar about India, and what were the strategies that you dealt with it? And since our focus today is on the U.S.-India corridor, how would you compare the way that awards are enforced in both of those jurisdictions?
Thanks for that question, Paku, and thank you for having me at this webinar. Very pleased to be here. Let me begin my answer by relating an experience that I had over the years, and this goes back quite some time ago. In 2012, I sat as an emergency arbitrator in one of the early SIC emergency arbitrations, and that involved a case between Swiss, or German actually, it was German and Indian parties over a consortium for a construction project in India. And the German party was actually seeking an injunction on a bond issued by an Indian bank. One of the problems that they had at that time, or they thought that they had at that time, was that in order to show that they were entitled to interim relief, they thought that they had to show that that they would suffer irreparable harm. And one of the issues they tried to get around that by saying that they would suffer irreparable harm because unless I stopped the call on the bond, then if the money was paid out and they subsequently got an award in their favor in the arbitration, they would take that to India, and India wouldn't enforce it. And they cited quite a lot of case law actually to me as explaining why Indian courts would not enforce international arbitration awards. And I think at that time, going back some 10 years, I think there was perhaps some validity in the cases that they were citing to me. But of course, I wasn't very keen as an arbitrator to write in my award or my decision that India would not enforce international arbitration awards. And so I didn't. And I found a way around it, and I was able to grant the relief that they sought. And as far as I know, that was complied with. But just as well that I didn't, because at that time, it was true there were a number of cases that made enforcement of awards in India rather unique, and one of which was that a very wide reading of public policy, which said that any decision that was contrary to Indian law, and the Indian courts looked at that guarded that very jealously, and if it was contrary to Indian law, they wouldn't enforce it. They say it was contrary to public policy. But fortunately for me, about a year or two after that, there was a big swing in the Indian jurisprudence on that, and the courts then decided that they wouldn't adopt the old judgments on that. They started to read public policy a lot more restrictively. And ever since then, what I've seen is actually the Indian courts have been getting far more fair and efficient with the way they enforce arbitration awards. So I'm very, very glad that back in 2012 I didn't fall for the claimant's argument and commit on paper that I didn't think India would not enforce arbitration awards, because in retrospect that is completely untrue now, and that is not the case. And so fast forward a number of years, and this time I am representing actually an Indian party in an arbitration. And that also actually was the SIC arbitration involving a number of foreign funds. And one of the issues in the case was a breach of a possible contravention of FEMA, the Foreign Exchange Management Act in India. And we ran an argument that because there was a breach of FEMA, there was possibly this was the arbitrability issues, and we also thought that there was a chance that the Indian courts may intervene in this, and because it did concern, if you look at, in one sense, a question of public policy, because FEMA is a question of India's public policy. Unfortunately for us, while that case was going on, there was another case that was going on, quite a high-profile case involving NTT, Docomo, and Tata. And that case came to a decision before our case came to a decision, before there was a question of enforcement in our case. And we saw that in that case, actually, a similar, or at least an argument on FEMA was taken, and that was disposed of by the Supreme Court. And the Supreme Court said that was not a reason not to enforce the award, and the award was enforced. And so, when it came to a situation where, on behalf of my client, we were looking to try and rely on the Indian court taking a public policy stand with regard to FEMA, and we found the Indian court didn't. And fortunately for my client in that case, they settled it before the award was issued, and therefore that didn't arise. But it shows what a big swing there has been in terms of the way Indian courts approach the enforcement of arbitration awards. And I'm fairly confident now that there is little difference between the way India approaches the enforcement of arbitration awards and many other arbitration jurisdictions, including the US, because as most people would know, the primary treaty that governs the enforcement of arbitration awards is the New York Convention. And most arbitration jurisdictions, the US and India included, follow the New York Convention. And here they are first of all, signatories to the New York Convention. Raj was talking about a situation where you don't come within the New York Convention, but that would be rather rare, because I think now it's 163 countries are signatories to the New York Convention. So there are very few countries that are not signatories to the New York Convention. And many of the jurisdictions, the US and India, enforce arbitration awards according to the New York Convention, according to the international standards by which the New York Convention is to be interpreted. And therefore, I don't see much difference at all in the way the US and India enforce arbitration awards, because they all comply with the New York Convention. And something Raj mentioned was the enforcement of interim relief. I know the US courts, some US courts have taken the view that interim measures can fall within enforcement under the New York Convention. And Raj has mentioned, the Indian courts are now, at least in respect of some arbitration awards, are willing to enforce interim relief. And there's still some question mark, as Raj mentioned, but I think, even in the situations where the court may not enforce the interim relief directly, they've been known to take an alternative route. They've been known to issue interim relief in the Indian court, but mirroring the interim relief granted by international tribunals. So in effect, you get the same result. So I'm pretty confident that as far as the rights that a party would expect to be protected under the New York Convention, you would get those rights protected in India and in the US, as with many other of the major international jurisdictions you find.
Stephen, thank you so much. I mean, that gave a lot of flavor to this topic on the overview of enforcement. And just following on from that, let's turn to Shweta. Shweta, you're in a unique position as the South Asia head for the Singapore International Arbitration Center. Are there any issues that you see in dealing with US-India disputes? Shweta, can you turn your mic on, please?
Hi, are you able to hear me now?
Yes, thank you.
Hi. So thank you, KCO and USIBC, for having us. I think this is a very, very significant webinar. As everyone outlined, that really the game changer lies in being able to enforce the award. While from the institution standpoint, we do not track enforcement, and our job pretty much is over once the award is issued. But it is in the interest of the institution, because it goes to the reputation of the institution to know, once you hear in the market, which award was enforced or not enforced. It would be like SIAC award. It would not be the arbitrator's name in that sense, or a particular institution. So from the standpoint of the institution, we do and try our best in the process, particularly the scrutiny of the awards, to ensure that the award is more enforceable. And the whole process of scrutiny, not only looks at the form, which tracks the procedural history, and ensure that the due process is duly recorded in the award, also looks at, is able to bring to the attention of the arbitrator points of substance, sometimes. And so these parameters in general, of course, I will get into the detail of what can be covered potentially in the scrutiny process. But generally, scrutiny is what enables and enhances the enforcement process. And the process, of course, remains the same, where you have an Indian party and the American party involved in the case. But if I were to, and I was thinking of this, that, what is so unique or maybe specific in dealing with American and US or Indian parties, in the arbitrations that we see at SIAC. And I think one remarkable feature would be, we've always seen Indian parties being very proactive, in terms of taking maybe parallel proceedings, so that's something is unique. If we were to compare it with parties from other jurisdictions, and so they are quite proactive in terms of whether wherever they would want to raise an issue in terms of the due process, while the reasonable opportunity is given to all parties. But that's something peculiar, and I think we're also mindful when we're looking at cases from with Indian parties being involved. In arbitrations involving the US parties, and this doesn't really go to the root of enforcement, but in general, the nature of the arbitration proceedings, which affects the timelines, is that those arbitrations tend to involve more discovery. They're sort of heavy on discovery where the US parties involved. So these are two unique aspects, if I could outline, for cases involving US parties and for the Indian parties. But from the enforcement standpoint, like I said, the heart of it lies in the scrutiny, to ensure that these are more enforceable and good quality awards, once they go out of the institution. And I think that's what really matters, even if you anecdotally, when we try and hear from the market, we've heard that the SIAC awards have been enforced in various jurisdictions, including India and the United States. And we've known that the reaction of the courts when we look at an award, that it's an SIAC award, there is a great degree of confidence, that the court looks at, that this award has been, of course, well drafted and been scrutinized and would be a proper order. So it would be seldom that we would hear that the award has not been enforced, when it has come from the SIAC.
All right, Shweta, thank you so much for that. And with you giving the final word on the overview, I think it's time to move on to our next section on interim measures. Before we get to the first question there, which I'm going to pose to Raj, can I please remind the audience that if you have any questions of our panelists, please use the chat function on your console for the webinar, and we'll try to get to those at the end of the program. So Raj, on interim measures, what immediate or interim measures can a party take to protect the subject matter of the arbitration pending the arbitration itself and then the consequent enforcement of the award?
Sure, Paku. But just before I answer that, I just wanted to add one point, and was that while a country may be a signatory to the New York Convention when where the arbitration is seated, but it is also important that it has to be ratified by India. Because otherwise, what happens is you may be a signatory to the New York Convention, but not ratified by India. You will still have to come and file a suit in India. So it's just not good enough for to choose a country where you want to seat an arbitration that has signatory to the New York Convention, but it is also important that country is ratified by India as well by a notification. So that's only one thing that I wanted to add and clarify when I wanted about the award. And of course, I must thank Stephen for mentioning NTT Docomo, because our firm was involved in that, and we were quite successful. We were successful, and I think that was a path-breaking judgment in enforcement of international awards in India. As regards getting an interim measure pending an arbitration, or at the time pending enforcement, there are a couple of ways in which you could do that. And one is by filing a Section 9 application, which is an application for interim reliefs in Indian court, even if the seat of arbitration is outside India, where one party is an Indian party. You could approach the Indian courts for seeking interim reliefs, even pending arbitration or even pending enforcement. One thing that we need to keep in mind while moving for a Section 9 relief or an interim relief in India is that at the time of drafting of the agreement, you have not excluded Section 9. Because if you have excluded that, you will exclude Section 9 as a part of enforcement, as for interim reliefs at the time of drafting of the contract, then you will not be able to take the benefit of coming to Indian courts for seeking interim reliefs under Section 9. Then in that case, when you come for enforcement, at the time of Section 47 and 48 application, you will have to file an application for along with your where you making an application for disclosure, to also make an application for attachment of assets and seek an immediate attachment of assets. So that's the way you will have to then protect the assets as an interim measure. Now, many a times people say, why do you need to go to court for interim reliefs, and why can't you go before the tribunal? By and large, you would go to the arbitral tribunal once the tribunal is constituted for an interim reliefs. And in fact, under the Indian law now, even arbitrators, the orders passed by the arbitrator are akin to the orders of the court. But when you're looking at an interim relief passed in a foreign jurisdiction, in an international tribunal, and you want to bring that to India, enforcement becomes sometimes difficult. So then you come and file a Section 9 application, and based on the Section 9 application and on the reliefs that you would have got before the international tribunal, you persuade the court to grant a similar injunction. So that's a mirror proceedings that you would take out in the Indian courts. But if you have kept a Section 9 open at the time of drafting of the agreement itself, you could straight go to the courts in India and seek that interim release from the courts in India, even at the time of pending arbitration or at the time of enforcement. You could still go to court and say that if the court does not grant me these injunctions, there are high chances that the counterparty may dissipate the assets of the company, rip the company apart of all its assets, siphon of funds, siphon of money, and at the end of execution, or at the end of the award, there will be nothing left for us to enforce or to attach. And keeping that in mind, the courts would consider granting an injunction in that scenario. If you have already got an asset tracing agency and who has already identified where the assets are, that becomes that much more easy to get an injunction from courts in India. So that is one of the very important aspects of getting an injunction. By and large, it's very important that you make out an important case that there is going to be a situation which will cause an irreparable harm to you if an injunction is not granted, and that balance of convenience is in your favor, that you have to you need to get this injunction. Otherwise, the assets are likely to get dissipated. You will have nothing left at the end of the enforcement. You could, at the time of filing your application for 47 and 48, that's for recognition and enforcement, while you file an application for disclosure of assets, at that time you could also request the court that we would need an injunction on the assets. And if the court is satisfied, court would either grant you an injunction at that point in time, or would court say that let the disclosure come and on the assets, what the assets are, and we will immediately grant you injunction. So that's also possible, and this is also a way in which you can take an injunction in courts in India. So these are some of the ways in which you could get an interim injunction in India.
Okay, Raj, thanks very much for that overview on interim measures. Let's turn to Stephen and your experience. Are there specific measures that a party can take to ensure that a foreign award is effectively and quickly enforced in India?
As we've been discussing now, enforcement in India is relatively swift, and we also do not see the issues of enforcement in India that we used to see going back quite a number of years now. That was a concern then. So I don't think there's anything particularly specific that one needs to do with regard to enforcement in India as opposed to other countries. But what you can do, obviously, is you need to make sure that you are careful not to have any of the procedural issues or breach of due process that might form a ground for non-enforcement under the New York Convention. Now, how would you be able to do that? I think the important thing there is actually the constitution of the arbitral tribunal. That is the key, because it is the arbitral tribunal that is to ensure that there is no breach of due process, that there are no grounds for procedural irregularities that would allow that would give ground to one of the grounds for non-enforcement under the New York Convention. So that's key, and that's only shows the importance of appointing the right arbitrators. The thing that I've seen recently in the cases that I'm involved in, involving India, is that increasingly you see foreign arbitrators or non-Indian arbitrators being appointed, whether seated in India or seated outside of India. I'm involved in a number of arbitrations seated in India. These are international arbitrations. And in a number of cases, there are two foreign arbitrators in these arbitrations seated in India, and of course I'm in arbitration seated outside of India, in Singapore and elsewhere. There are again a good number of foreign arbitrators, experienced foreign arbitrators, and I think if you've got a good arbitral panel, then the chances that you're going to have a breach of due process or a procedural irregularity, would be limited. Let me just also, before I finish, I'll just pick up on a point that Raj was talking about. Interim measures, because I know interim measures is important in Indian-related cases. From the experience I've had, I know parties seek interim relief quite often, especially Indian parties do seek Indian relief, whether in the Indian courts or before the arbitral tribunal. There is one thing that since we're talking about arbitration involving India and arbitration in India, is that one thing that is slightly different about arbitration in India is that the Indian Arbitration and Conciliation Act gives the court the power to review interim relief granted by arbitral tribunals seated in India. And that is unusual because not many other jurisdictions, in fact, as far as I'm aware, India is the only jurisdiction, and there may be others, but as far as I'm aware, India is the only jurisdiction that gives the court the power to review interim relief by arbitral tribunals. In most other jurisdictions, the arbitral tribunal's determination on interim relief is final and is not subject to review by the court. I think that is, it does give rise to a bit of difference in the way interim relief is approached, because if I'm sitting in an international tribunal, I'm going to decide interim relief as far as I'm concerned by international standards, particularly in an international case. And it is not subject to review by the court, so that, you know, I know that my decision cannot be challenged unless it's you know, becomes a question of enforcement and whether it's enforced. But at least as far as interim relief, you know, it cannot be challenged, you know, because it is interim relief. Whereas in India, because of the court's power to review, and I was in a case recently sitting in India where there was an interim relief that the tribunal had to grant, but we knew that in either case, whether we granted or didn't grant it, there would be an appeal to the court and the court would decide it. We felt compelled as the tribunal to consider the jurisprudence that the Indian court takes to dealing with interim relief and deciding according to that. So I think there is a difference in because of that, but it's not a, I wouldn't say it's a major issue, but it is a difference that I've noted in interim relief as far as arbitration seated in India is concerned.
Thanks, Stephen. And Shweta, let's talk for a moment about emergency arbitrations. And given the fact that the Supreme Court of India has recognized emergency arbitrations with respect to India-seated arbitrations, have you seen any changes in parties' approaches to emergency arbitration invocation?
So, emergency arbitration has actually been one of the most popular procedures at SIAC, and especially in cases involving Indian parties. If I were to mention some statistics, majority of the applications of EA actually came in cases involving Indian parties. And this was the case even before the Supreme Court's decision confirming that EA decisions can be enforced in India came about. So it had always been very, very popular. While we've not recently seen any dramatic rise in the number of EA applications post Supreme Court's decision, and that could partly be because the decision is has only clarified, you know, the ambit where the EAs are in cases where seat is in India. So what happens to cases where seat is outside India remains to be a gray area so far as enforceability in India is concerned. But like I said, you know, it is a very popular provision in cases involving Indian parties. So no direct impact as yet. You know, maybe we will see, you know, if there are more cases which are seated in India, if the parties are more amenable to EA applications.
Okay, thank you, Shweta. And I think let's move on to a topic that I guess chronologically would come first, but we're taking this sort of as our last major topic, and that's what do you do before a dispute even begins? What are the strategies that you can consider perhaps before you even sign the contract with the counterparty? So Raj, can you give us some ideas on what those strategies might be before a dispute even arises?
Sorry, I had an issue with my mic. See, I'll put it in broadly a couple of three buckets. And I'll give you a very bullet point answers to this, because these can be a webinar in itself as to what strategies you could do, or what are preventive actions that you could do. But I would say the first would be at the time of drafting itself, that you keep in mind drafting of your arbitration clause, because that's where the genesis of arbitration is, and that's where eventually, if your arbitration clause is right, and if you go into arbitration, things will start falling into place. So I would say have a good and effective arbitration clause. You decide whether you want to do an institutional arbitration or an ad hoc arbitration. You draft your clause accordingly. If you're looking at an institutional arbitration, please look at the rules of the institution. Like SIAC has a model clause. Use the model clause as far as possible. You may need to tweak it here or there, but as far as possible, pick up the model clause and use them. keep your, I would say, be very clear about the seat of arbitration, because we see a lot of confusion on seat, venue, place, and there are multiple different connotations used for the same thing. So use seat as a phrase in your drafting of your arbitration clause. Also, many organizations prefer that there are discussions even before it goes into arbitration, and they would want at different levels, they would want the discussions happening. Maybe first is at a mid level, and then it's a CEO level, or if they even want a formal mediation as a process before it goes into arbitration, then you need to build that into your contract itself. These are very effective processes uh, to have a pre-dispute strategies, whether you could have two CEOs meeting to see if the matter can be resolved. If not, then maybe you want to escalate it to a mediation, a formal mediation process. This is at the time of drafting of the clause. The second step would be during, if it's already likely to go into the dispute, when the contract is already running and you think that now you've tried a lot, nothing is working, and it's likely to go into dispute, ensure your correspondences that are going on are reviewed properly by lawyers. You know that you're not giving up positions. Whatever stand that you need to take are there in your correspondences. Whatever positions that you need to take are taken in those correspondences. They're legally correct. So it's very important that those kind of things are already in place. If there are any settlement discussions, you're writing the correct words, you're putting in the without prejudice discussions, and without prejudice as in the correspondence and things like that. You're not admitting to any amounts otherwise in your correspondences. So those things are very important that you do. And probably the third one would be uh, just before enforcement, or when you're going in for enforcement, before ensure that you have got an asset tracing agency or a body which is, or you know from within your organization where the assets of the other parties are, so that if you have to actually go and enforce it, you know where the assets are located. It becomes easier to enforce. Second, be clear as to which court or which country you want to go and enforce, because you may have an option of going into multiple countries. So you'll have to choose which is the best country and the quickest way to get an enforcement of an asset, which will build the pressure on the counterparty. So you need to do that as one of the important part. Uh, uh, if you need an interim measures from any court, you need to also think about that and start building that into your strategy, that you may need to go and move for an interim relief. So I think, to my mind, these are some of the key points that you need to keep in mind, and that these are like pre-dispute strategies that you would probably start using as the matters progress.
Thank you, Raj. And I also want to get some thoughts from both Shweta and Stephen on these issues, particularly on arbitration clauses. So I'm going to blur a couple of the questions together. I just want to remind the audience to please use the chat function if you want to ask our panelists a question. We already have questions coming in, and I'd also refer my panelists to those incoming questions. But Stephen and Shweta, same question for you, effective pre-dispute strategies, and then with respect to specifics on arbitration clauses on the seat and the arbitration institution, any guidance for our audience?
Stephen, you want to go first, or you want me to take this?
I'm happy to just throw in a few words now on as pre-dispute strategies. Raj has covered a wide gamut of these. The one thing I want to emphasize is mediation, and I think mediation is growing in popularity as a dispute resolution process, both internationally. I think in India as well, there's increasing interest in mediation. I think it's an effective means of resolving a dispute, and it's certainly something to consider, whether it's before you go into arbitration or even while you're going through arbitration. Even though I have spent my entire career either as someone acting as counsel in arbitrations or sitting as arbitrator, and therefore it is in my professional interest to see cases go to arbitration. I always believe that it is better for a party to settle a dispute than to roll the dice and let the decision maker make a decision. And I say that even if I am the arbitrator in the case, and I believe I'll come to a fair and correct result, but it always will be better if you can settle the dispute. So let me reinforce mediation as an alternative means of dispute resolution. On arbitration clauses, the best advice that I can give actually is to use the model clause, assuming you're choosing institutional arbitration. And there are many reasons why you would want to choose institutional arbitration. This is not the topic that we're talking about, but if you are choosing institutional arbitration, choose the model clause. And I can say this from experience, that there are two cases that I've been involved in where there's been a pathological arbitration clause. One actually involved the SIC. This goes back a number of years. The SIC model clause refers to the rules of the Singapore Singapore International Arbitration Center, and there was a case that I was involved in where the clause was the rules, the Singapore International Arbitration Center rules. So it referred to the Singapore International Arbitration Center rules. So effectively, it was one word. In the model clause, the rules comes before Singapore International Arbitration Center, and that clause came after. And that led to the case being stuck in the Singapore courts for a year and a half, in the High Court and in going on to the Court of Appeal. And the reason for that was because at that time, for a brief number of years, the SIC had two sets of rules. There was the international rules and the domestic rules. And when that clause was entered into, actually, there was only one set of rules. It was the international rules. However, when the dispute arose, the domestic rules came up. And there was an argument as to which set of rules applied. And funnily, if it had read the rules of the Singapore International Arbitration Center, that would have been taken to refer to the international rules, and there would be no dispute. But because it referred to the Singapore International Arbitration Center rules, the court held that, well, this referred to the rules generally, the Singapore International Arbitration Center, and therefore, in that case, the domestic rules applied. But my point there is a simple deviation from the wording of the model clause can get you stuck in court, for unimaginable reasons. I mean, there would have been no issue if the domestic rules did not come up after the clause was drafted, but it happened, and that's what happened in that case. Another case I can talk about is actually one involving India, actually Indian parties, where in that case, it wasn't institutional arbitration. Well, it was a failed institutional arbitration clause, because the clause referred to arbitration before the Singapore International Chamber of Commerce. So we know the ICC, the International Chamber of Commerce, offers arbitration services. It's one of the big providers of arbitration services. And if it had said the ICC seated in Singapore, it wouldn't have been a problem, except this one referred to the Singapore International, the Singapore, basically in Singapore International Chamber of Commerce, which it does exist. There is a Singapore International Chamber of Commerce, but it doesn't offer arbitration services. That then became a defective arbitration clause. I was appointed as arbitrator by the SIEC, but the chairman or the president of the SIEC, but being the default appointing authority in Singapore. But that case also involved a challenge, because in that case, then the parties accepted it was ad hoc arbitration, the reference into the institution having failed. But there was a big dispute as to whether the seat was in Singapore or in India, and I was appointed in Singapore. There was an application made to the Indian Supreme Court for appointment of an arbitrator in India. I was fully expecting there would be two arbitrators, because the Indian Supreme Court would appoint an arbitrator, and there would be two arbitrators and a race to an award. But to my surprise, and to the credit of the Indian courts, and this is one of the judgments that which showed a bit of the change in the approach to international arbitration in India. The Supreme Court said that since an arbitrator has been appointed in Singapore, and by then had issued an award which said that the arbitration was seated in Singapore, they said the arbitration is seated in Singapore, and therefore they declined to appoint an arbitrator. But that's another example that I've personally been involved in, where if you don't get the clause right, you find that it can go terribly wrong. It can really go terribly wrong. So the easiest way to get the clause right is just to use the model clause that the institution provides.
Shweta?
So I think maybe if I could just summarize what would be the contents of an effective arbitration agreement, and principally those are four. So first is that the parties must clearly set out in their drafting their intent to arbitrate. So the submission for agreement to arbitrate must be absolutely clear and unequivocal. And this must also clearly provide for the types of disputes that shall be resolved by arbitration. So the clear drafting of the arbitration agreement. Second, the governing law must be clearly set out in the arbitration agreement, and to that the governing law of the contract and the governing law of the arbitration agreement. The parties can choose the two to be different or the two to be the same, but it's better that they identify what the governing law of the arbitration agreement would be. Then thirdly, very, very important, which both Raj and Stephen alluded to, is the seat of the arbitration. A problem arises when the parties don't identify what the seat is, or use the terminology which may or may not be sort of identified by the courts as the intention of the parties to be the seat. So to clearly set out that the seat of the arbitration, without mixing the words of place or seat and anything else to the contrary of what the intention is. Again, without any bias to any jurisdiction, I think when deciding on the seat, there are a number of factors that the parties must look at. When you are really choosing or even negotiating between themselves of what seat should they opt for in their arbitration agreement. Firstly, that of course it must be a signatory to the New York Convention, and of course the ratification that Raj mentioned. The seat must be one which has a robust legal framework. Also the legal system which is neutral and impartial. Again, an important criteria, and I was really looking at the seat in cases involving India and US parties. Of course, both on the first line of negotiation would want to have their own countries as the seat, but it's best to have a neutral, and that's why we've also seen an increasing number of choice of Singapore as seat in cases with India and US parties. So you want to have where you also feel a comfort of that the legal system is neutral and impartial to either of the parties. Again, and I think for that, India has also come a long way. You want to have a seat where the judiciary has established the reputation of being non-interventionist and pro-arbitration, and has had a track record in enforcing agreements to arbitrate and the arbitral awards. So a number of factors when you're deciding the seat. It's not just a matter of, it is not a matter of physical convenience when you're choosing the seat. Seat is really the legal home of the arbitration. So parties, would need to be very careful. And the sad story, Paku, is that the arbitration agreement is still considered as the midnight clause, and really like the last thing that gets talked about or discussed between themselves, but often the one which gets them into the trouble the most. Once the dispute arises, all of these things come out. The seat has not been identified or not been carefully chosen. The governing law has not been identified, or the intention to arbitrate is ambiguous, in terms of what the ambit is, of the dispute that they wanted to refer to arbitration. And lastly, the procedural issues, which is the fourth point in terms of the content of effective arbitration agreement, to be able to clearly identify the procedural rules that the parties would want to apply. For example, the institution, like Stephen mentioned, some of these examples of pathological clauses where you have mixed two institutions or named an institution that does not exist. And how it is the best practice is to be able to take the language from the model clause of the institution that you choose itself, but to be very, very clear, to know that the rules actually exist, when you are writing them into your arbitration agreement. So these procedural aspects, also the number of arbitrators, to avoid a conflict later. If you know the dispute is not very high value, maybe a sole arbitrator would be good. But if it's complex, high value, maybe to have 3 arbitrators, and to identify these things at the stage of drafting itself would be very, very important. Again, of course, I'm representing SIAC, but without any bias to suggest to SIAC, it's also important when parties are choosing the institution in their rules. And of course, we've all heard about the benefits of having an institution sort of overseeing the process of arbitration, the value that it brings in terms of cost and time efficiencies to the arbitration. But even within the institutions, there are a number, that exist even amongst the top leading institutions. But some factors that the parties may want to consider is, of course, the experience of the institution. For example, if I'm an American party and I'm contracting with an Indian party, I would want to take an institute which has had an experience in cases involving Indian parties, who understand the realities of transacting businesses in relation to in Indian parties in international contracts. You would want to have an institution which has a robust pool of arbitrators. But of course, as Stephen said, that at the heart of enforcement really goes the quality of the arbitrator. So an institute has a very important role in choosing good arbitrators. So you want to make that choice right. The reputation of the institution, the quality of the staff itself, and again, a very, I think maybe we don't pay too much attention to this, but very, very crucial, and which is what I experience when I speak to the corporates, both American and Indian, is the accessibility with the institution itself. You're not at arm's length with the institution when your case is being run by the institution. How easily the institution is accessible. You can just pick up the phone and understand, even at the drafting stage of the arbitration agreement, or once the dispute has arisen, how do we go about sort of applying the rules to the case to make the process more efficient, to rule out factors that could affect the enforcement at the later stage. And I think that sort of proactiveness at the stage of drafting would go a long, long way in ensuring that the enforcement is tighter and you don't sort of leave things hanging, and which could hurt you later at the time of the enforcement. Sorry, I sort of ran a bit of extra time, Paku, but I just wanted to share some.
Unbelievably, no, that's unbelievably practical advice, and same for Stephen and Raj, and I think that's exactly what the audience needs. We are running a little short of time, so I'm going to continue with the questions, but I'm going to ask the panelists to maybe shorten their time just a little bit. So Raj and Stephen, what do you do when a dispute is imminent? What's the first step you take? If we can just maybe take a couple of minutes for the both of you on that.
Sure.
So Raj, you want to start?
Sure. Generally, when you know that the dispute is imminent, you would absolutely start ensuring that your correspondences that you're going to have with the parties are absolutely correct and are being vetted through some lawyers. So it's important that they look at the correspondences. Second, as I mentioned, and maybe it may be overlapping with the previous answer a little bit more, is that when you when you know where you have to enforce the award, you know where the assets of the counterparties are, and you know when you need to go and attach, where you need to go and attach the assets, you need to ensure that your seat of arbitration is at a place that has a reciprocating arrangement with a country where the assets are. You don't want a situation where you have a seat of arbitration in a particular country, asset in a third country, and both of them are not reciprocating to each other. Otherwise, so you will not be able to enforce that. So keep that also in mind. And maybe just one more point before I can say is that while you are also drafting your arbitration clause, two other things that you can probably keep in mind is that if there are going to be multi-party arbitrations, so if there are going to be multiple parties in an arbitration, you may need to draft your arbitration clause keeping that in mind. Also, while drafting the arbitration clause, it's very important to understand the local, understand the arbitration laws of the country where the seat is going to be, because sometimes you will find peculiarities in the country where your seat of arbitration is. They may have a peculiar laws for arbitration, and if you don't know them and you've chosen a particular seat, you don't want a situation when arbitration starts, you start figuring out what the law is. You don't want to be out of sight of something where you're going for an arbitration. It's very, very important. Uh, Also, when you're drafting this arbitration clause and preeminent likely that this dispute's going to happen, you want to invoke arbitration, you must also know which are the what disputes can't be referred to arbitration, like a disputes like a criminal matters can't be referred to arbitration. So those things also you need to keep in mind that yes, while we are already in dispute, but what are the kind of disputes that we are referring to arbitration? Disputes in rem can't be referred to arbitration. So these things we need to keep in mind.
Stephen, any
Uh,
thoughts?
Very briefly, I agree with Raj. Well, the first thing you need to do if you think you're going to go to dispute, you're going to get into arbitration, is to collect your records. That's essential. Much of commercial disputes these days are all recorded. Many of the contract would be written, correspondence would be written quite likely in email. And you want to make sure all your records are in place. That's really essential. The other thing I would add is this, that this is coming from the perspective of being an arbitrator, but also as counsel, which I think, particularly for the claimant, formulate your legal case, especially for the claimant. If you're going to bring the case, then you have to know what case you're bringing. And quite often, I see that counsel want to maybe reserve their position and be vague about the case that they're bringing, in the view that maybe they can adapt it later. But I think it's important for a claimant to be very clear about what case they're bringing at the outset, and to formulate the legal case, and to then follow that legal case. Of course, if something comes up later in the case and you need to change it, it's fine. I don't think it's held. I've not come across a case where a tribunal would hold it against a party that you're changing the case. People accept that the cases can change, and the rules allow a party to change a legal case. But so I don't think it's an issue that you have to change your case later. And most of the time it is allowed, and it's perfectly acceptable. It's not held against you. But what is a bit jarring to a tribunal is to see that a party isn't clear about what case it's bringing. Because that was something would be noted about tribunal, that you're actually not quite clear exactly what case you're bringing, and that is disturbing to a tribunal.
Thank you, Stephen. And let me just finally turn to Shweta, and we're again, Shweta, deeply honored that a senior official from SIAC could join us here. Just wanted very quickly, because we are running short on time, how SIAC supports parties who adopt its rules, and how the opening of your office in the United States has in any way affected the administration of arbitration between Indian and US parties.
So, I mean, if I could just summarize, what would the administration of cases at SIAC, what would we do if you choose SIAC rules in your contract? So SIAC would undertake the appointment of arbitrators, which is done by the president of the SIAC Court of Arbitration, who's Ms. Lucy Reed, based in New York. And even if the parties were to nominate their arbitrators, they are subject to the confirmation by the president. Second, we would supervise and monitor the progress of the case. Thirdly, we will look into the financial management of the arbitral process. We will fix tribunals' fees and other terms of appointment. We will render accounts and collect deposits towards the cost of arbitration. We will process tribunals' fees and expenses. And lastly, and which is what I began, my first point is the process of scrutiny of awards. And this goes to the heart of the enforcement process. Of these functions, I think the two most important would be the appointment of arbitrators and the scrutiny, which will really enhance or increase the value in terms of the enforcement process itself. If I were to give some examples of what are the aspects that we would look in the scrutiny. So essentially, once the proceedings are closed, the arbitrator will give a draft award first to SIAC. So it is not issued to the parties by the arbitrator directly. The draft form is given to us, which when we then scrutinize the award and submit our comments to the arbitrator to take into account, which would include the form and could also have points of substance to which we wanted to bring the attention of the tribunal to. And these essentially some examples of the aspects that we would look is first, whether the tribunal has clearly and correctly set out the procedural history, the commencement, appointment, procedural applications. This again is a very important part because this will affect the ground, when you are enforcing the award as one of the grounds on which the enforcement can be resisted is due process, where the party may argue before the court that the sufficient opportunity was not granted or they were not heard. Again, we will also look at have there been any procedural irregularities which needed to be addressed by the tribunal and has not been done so in the award. Whether the tribunal has set out the issues in dispute completely and accurately, or whether the award actually reach a determination on all of the issues in dispute, or if the tribunal has gone beyond what had been submitted to the tribunal, we will, of course, tell the tribunal that you might want to reconsider this. Of course, if the award is issued on a point which was not raised or within the ambit of the arbitrator's mandate, then that would become a ground for resisting enforcement again. And again, very important lastly is whether the parties have been given an opportunity to address all of the issues in dispute before on which the arbitrator has decided. So these, of course, are some of the factors that we would look on in terms of the scrutiny process. Now coming to your second question of what has changed in terms of the case administration after the opening of the New York office. So SIAC's New York office, which was opened in response to the steady rise of cases or involving US parties, and this was really our commitment in a way to be able to allow us to foster deeper ties with the US users and more importantly to allow the US parties to be able to benefit from real-time access to SIAC. While the case administration, of course, continues to be done centrally from Singapore, we now have a SIAC rep who's seated in the New York office. So this will allow for the parties to be able to reach out and to be able to sort of engage deeply to understand how the rules would apply. And this would, like I said, the case administration is still being done from Singapore, but this would allow them to be able to more efficiently use the rules in their arbitrations and to have more efficient resolution of their business disputes.
Okay, so Shweta, Stephen, and Raj, thank you so much. That concludes the panel discussion portion of our presentation today. And I really do appreciate the practicalities that you've given on enforcing the arbitral award in India. I think it's really helped. We have limited amount of time, about 7 minutes, I think, for questions. And we have several questions that have come in both before the webinar and during the webinar. So I'll ask my panelists that let's take the questions that came in during the webinar and then we'll take some of the other questions next. But I'm going to exercise my moderator rights and ask you the first question, and that is, each of you in 30 seconds or less, if there's one thing that you want our audience to remember, what would it be? And because we are short on time, 30 seconds or less, and let's hear from Shweta, Stephen, and Raj in that order, please.
So I think for me, one comment would really be you will make a wise choice. And I think that's the most determinative factor, when you're looking at the enforcement later, is really the choices that you make at the time of the drafting. If that's done right, you will really cut down on a lot of problems that you would have otherwise faced later.
Stephen?
From me, it would be this, that I have been involved in India-related disputes for about a decade now. While there may have been some concerns in the past about the way India approaches international arbitration awards, I would say now I have absolutely no hesitation about international arbitration, whether seated in India or seated outside of India involving Indian parties. Absolutely no hesitation that you get your award enforced in India. Absolutely no hesitation that international arbitration will be conducted the way it is conducted internationally involving India and Indian parties. Absolutely no hesitation at all.
Thanks. And Raj? Can you please turn your mic on?
Sorry, I quite agree with Shweta and Stephen both, and I would only say that prepare well for enforcement if you're looking at enforcing the arbitrations in India. Be meticulous from the beginning. Keep things clear, what you want, where you want, keeping the timelines in mind. Indian courts have become very proactive and arbitration friendly. They will not interfere with the arbitral award. They will grant you your enforcement. So I think you just need to ensure that you have ticked all boxes before you file your enforcement. You got everything in place, and then file for enforcement, so that you are not disappointed or then not feeling that it's got delayed. I don't think the courts are very proactive now.
Okay, thank you. And thank you for keeping to 30 seconds or less. We have about 5 minutes for questions. So let's take, I think, one of the last questions that came in on mediation and conciliation and other forms of alternative dispute resolution. The question is whether the parties can impose that, but I'm also curious whether the arbitral tribunal could actually request that as well. And I'll throw that to any one of the three of you.
Stephen, go ahead. You're the arbitrator and a counsel as well.
Let me just begin with that. Well, I think the question was, can you insist on mediation if it's not included in the dispute resolution clause? And the answer to that is no, in that mediation requires consent. If anything else, it does require consent. And therefore, if you haven't agreed to it already, you can obviously agree to it after the dispute has commenced. Both parties agree that you want to mediate, and that's perfectly fine, but you cannot force the other party to mediate. And even if it was in the clause and you had to go to the mediation, but the other party was unwilling, then it wouldn't work. The other question is whether an arbitrator can impose mediation. The answer is no, it is not for the arbitrator to say, you have to go and mediate, because the arbitrator's mandate is to decide the dispute. An arbitrator can suggest, can at appropriate time say, have you considered it? It might be something you might want to do. But if the parties don't want to do that, then the arbitrator has to see through his mandate, which is to decide the dispute.
And so, Stephen, I guess the key word here is agreement, right? And that's all goes to thinking ahead on how you want to structure this from the beginning. All right, just a quick question. What is the status of emergency arbitration in the United States?
Perhaps I could just comment on that. If you're talking about the US, so actually, the concept of the emergency arbitrator was, I think, primarily developed in the US. The ICDR or the AAA first came up with the idea of using emergency arbitrators. They included it in their rules. The SIAC was the first Asian institution to adopt it more than 10 years ago now. I think it was probably around 2011 or so that they brought it into their rules, or 2010 actually. I think it was 2010 that they brought it into their rules. And then it was followed by many other institutions, so that you see that emergency arbitrators are widely used everywhere. But the US is the place where it started. That's where you first started seeing emergency arbitrators. So it's a jurisdiction that has a lot of experience with emergency arbitrators.
Okay, thank you, Stephen. And I think in the interest of time, we only have time for a couple more questions. So Raj, let me ask you a question. And these were some of the questions that came in before the webinar began. Are there any specific issues, for example, timelines and costs that a party needs to keep in mind before it tries to enforce an award in India?
I think the timeline, as I mentioned in, earlier as well, it would range from 1.5 years to 2 years for an enforcement. But if you want an interim relief, you'll have to come quickly, and that you'll be able to get the moment you file an application. You'll be immediately be in a position to move for an urgent hearing. But if you're looking at a full enforcement, it'll take at least 2 years, to my mind, to get your enforcement in the Indian courts. Cost depends on various and multiple factors. So it's very difficult to predict the cost as to what could be the cost. It depends on the number of hearings, the kind of lawyers that you engage. So it has multiple variables. That will be very difficult to kind of comment at this stage.
Oh, all right. Thank you, Raj. And Shweta, let me ask you the last question, and then we're going to need to conclude. If you can just take a minute on this, but in your experience where there's an arbitration between an Indian and a US party with SIAC as the arbitral institution, what has been the most popular seat for the arbitration itself? And have you seen any changes over the years?
So Singapore has been the popular one, I think principally because of neutrality for both parties. But we are also seeing India emerging as the seat, even where there is an Indian party and a US party. But the predominant seat remains Singapore in cases involving Indian and US parties.
Okay. So, ladies and gentlemen of the audience, that concludes our program for today. We're exactly at the 89th minute. First of all, I want to thank so much Shweta, Stephen, and Raj for this great presentation. I think it's been practical. I've learned a great deal myself, and I know that the audience has. And I think it also is a testament, based on the comments that they've made, about how dispute resolution, which has been an issue regarding India, that there are real solutions to this, and there are real ways of enforcing those awards to resolve disputes so that parties can go on to doing their business. So I think that that's really, really critical. I finally also want to thank very much the US-India Business Council and the SIAC for sponsoring this. So Shweta, particular thanks to you, as well as to Amy for the US-India Business Council. And most of all, to the audience, we thank you so much for attending tonight. I know that it's some places morning, some places afternoon, and some places very late at night. We deeply appreciate the interest that people have had. And I think on behalf of the four of us and Ketan and Co, thank you very much, and good morning, good afternoon, or good night.
Thank you, Paku, Stephen, Raj, and thank you.
Thank you, everyone.
Thank you, everyone.
Thank you.
Great to be part of this.
Thanks.
Thank you, Paku. Thank you, Stephen. Thank you, Shweta. Thank you, everyone.